when it comes to the disputes itself, I think a lot of people, when they write their will, they always appoint this person called the executor. So is it very much on the executor role to actually to perform this mitigation before it comes to you, or?
So unfortunately, when appointing the executor, the testator, who is the person writing the will, he or she does not need to inform the executor of their role. Right? So only after the deceased passed away, then the executor realized, oh no, I'm being appointed as executor. Why is it my responsibility? I don't even know what the deceased wishes are because he or she did not share it with me. So because of that, when writing a will, we always recommend the clients to always speak to the executor, their intended executor first, before they even put their names inside, so that they are not taken aback by the appointment, and also so that they know what their roles and responsibility are towards the deceased at that point in time.
Yeah, so actually, I think over the years of work and all this, I think when people wants to write a will, it's very much the focus is always on the distribution, but they tend to neglect some other important things like the roles of the executor, appointing who as the executor, and usually people have this misconception that I just appoint my elders to be the executor, and then knowing and hoping or knowing that they will know what to do, right? But I think it isn't always the case. I think a lot of times the executor may not have performed the job well, and it caused a bit of disputes among the siblings or the other beneficiaries. So when it comes to this part of things, and how can do you think that they can try to, maybe you can share also, like, what do you think what are some of the key important aspects that the executor has to know, so that when the testator writes the will, they can inform the executor first?
Okay, first and foremost, the most basic thing that the executor should know is, of course, the assets of the deceased. So ideally, the executor should be someone who is very close to the deceased or have a very good relationship with them and have already discussed their assets list. Minimally, what kind of assets they have. For example, maybe a bank account in Bank of China, a safe deposit box in UOB. At least these are discussed when the testator is still alive. So the reason why I say that is also because after the testator has passed on, the executor's job is to go to all these institutions to retrieve the assets on behalf of the deceased, right? So if the executor does not know the kind of assets that the deceased have, they don't have a starting point, and that is quite worrying. And we have seen that in many cases where people actually come to us with a will and say, oh, my dad passed away, can I go and execute it? So we tell them, sure, you can go and execute it, but what assets do they have? And unfortunately, the children will say, oh, I don't know, my daddy never tell me anything when he was still around. So that is number one, first and foremost, very, very important to have a list of assets. Number two is definitely the executor needs to have some form of financial management capabilities. They should at least know, for example, if money is in a bank, that's quite straightforward. But if there's monies in like the CDP account, there's monies like in a property, for example, ideally the executor should be someone who is equipped to handle these different asset classes and also be able to liquidate them properly and be able to split it to the beneficiaries. Honestly, it is a lot of work. So for example, for couples who are not that young, we will always suggest that perhaps you may want to consider putting your children or your niece or nephew to assist as the executor in the event of you passing away instead of their spouse, because their spouse may be about the same age as them. If they unfortunately pass away, it might be quite a strain on the spouse to run around and do all this legwork for the estate.
Okay, so I think with the appointment of this executor, so a lot of times I always share is that people always stand from their point of view. So when the testator writes the will, they assume that everybody knows what to do, right? And then they will just assume that this asset will be distributed in this way, and the executor know who all the other beneficiaries well enough to see how they want it to be distributed.